You're seated, is it? In your living?
Yeah, because it's a Zoom mood.
Zoom moves.
Yeah.
Oh, okay.
Okay.
Just note, we might not be replying each other directly because we'll be replying, responding based on the outlines. So
How does that work?
so the petitioners will be responding to team 12, right? So if you see an outline, a team 3, petitioners outline team 3.
Okay. All right.
Yeah, so that's the outline of their arguments. And then they'll be responding against the team 12 respondent.
Okay.
Yeah.
But on the actual day, this is what you're supposed to do.
Yeah, because
Also, they told you already.
yeah,
Oh, so this is not live.
basically.
No.
Huh?
But we need the judges' questions and all that. We need to simulate that also.
Oh,
So the actual day will be live,
Yeah, it'll be live, but
this practice is not live, lah. It's
Yeah.
not-
Yes.
it's not-
yeah.
no, but they are also bound by this. Everybody is bound by
Yeah.
this.
Oh, yes.
So you already know the arguments the other side is going to make.
Yeah.
Then, okay.
Like before each round, we'll create a new outline based on
Okay. Okay, so let's pretend I don't read the outline. I don't know anything, but I know what you're talking about.
yes.
Okay.
Roughly.
If I may begin. Your Honours may please this court. My name is Ryan Low, and together with my co-counsel, Mr. Chester Ong, we appear on behalf of the petitioners, the Fairland Group of Companies. Mr. Ong and I will be speaking for 14 minutes each, and we reserve 2 minutes for rebuttal. I'll be addressing this court on the first issue concerning the recognition and enforcement of the Utopian Court's order for consolidation. And thereafter, Mr. Ong will be addressing this court on the second issue concerning the release of third-party claims. Today, we ask this court to recognize and enforce the Utopian Court's order of consolidation. And if successful, the substantive consolidation of the Fairland companies would take effect here in New Zealand. This means that the assets and liabilities of the Fairland companies will be pooled and any intercompany claims would be wiped out. The only issue for this court to decide on today is whether the recognition and enforcement of the Utopian Court order is contrary to New Zealand's public policy. And this is pursuant to Section 1506 of the New Zealand Insolvency Statute. We submit that it is not contrary to the public policy of New Zealand, and for the purposes of this hearing, we shall assume that the preliminary requirements for recognition and enforcement have been made out. Now, it is tried law that the public policy exception has a high threshold due to the inclusion of the word manifestly in the New Zealand Insolvency Statute. And this was noted in the House report on the Bankruptcy Code. Now, it can only be established, the public policy exception can only be established in two situations. The first, where there is violation of a fundamental statutory or constitutional right, or second, where there is evidence of procedural unfairness in the foreign proceeding. Now, the respondent argues that the present case fits into these two categories of public policy. But our position is that the facts do not show that a fundamental statutory right has been breached. And second, neither does it point to the existence of any procedural unfairness in the utopian proceedings. I'll move to my first submission on the violation of a fundamental statutory right. Now, there is no violation of a fundamental statutory right here in New Zealand. And the reason why we say so is because substantive consolidation is also available as a remedy in New Zealand's own domestic insolvency proceedings. This power is found under Section 1123 of the New Zealand Insolvency Statute, and judicially recognized in the 1988 Second Circuit decision of Ray Augie Restivo. Now, this means that any effect it would have on the creditors is acceptable in New Zealand, and this is contrary to what the respondents argue at paragraph 3 of their written outline.
Were the creditors support obtained in Utopia?
Yes, it was. That can be seen at paragraph 24H and paragraph 25 of the facts. The court subjected the approval of the reorganization plan to a 75% approval and subsequently ordered and approved the reorganization plan.
But was it actually obtained?
But we asked this court to draw this inference based on the fact that the 75% approval was made a requirement, and thereafter the court approved the plan, presumably on the basis that the conditions that they had set out were satisfied. Now, the crux of the respondent's argument in relation to fundamental statutory right is that substantive consolidation amounts to a deviation from New Zealand's priority scheme. But we say that any deviation as a result of substantive consolidation is acceptable because the courts of New Zealand can order substantive consolidation in their own domestic restructuring proceedings.
A bit more the consolidation order. What does it consolidate? What are the things being consolidated under the consolidation order?
So the consolidation order would have the effect of pooling the assets and liabilities of the Fairland companies. And that would also mean that any intercompany claims would be eliminated, specifically a 7 million loan between the holding company and one of the subsidiaries.
Okay.
And we say that because of these effects, the fact that it only extends to the pooling of assets and liabilities, it cannot have the effects which the respondent contends at paragraph 3 of the outline. So at paragraph 3, they argue that there is a deviation of priorities, but as we see at paragraph 3A and 3B, their contention lies with the fact that Rover Capital, one of the shareholders, would gain priority, but they overlook the fact that in this case, Rover Capital gains priority because of the fact that they will be providing rescue financing under the terms of the reorganization plan.
So you are saying that even though it's consolidated, Rover still has priority.
Yes, but not because of the consolidation, but because of the fact that they are giving rescue financing.
So it's in order for them to get the priority is because they are putting something new in, right?
Yes.
But if they didn't put anything new in, without the consolidation order, they will get priority.
No, we say that is not the case.
Why is that not the case?
Because the reason why they are getting priority is because of the fact that they are putting in something new. If the consolidation would not occur, then there would be no change to the priorities of distribution.
So let's say without the consolidation order, where does Rover stand?
Rover will stand as a shareholder.
So it has no priority.
Yes.
Okay.
And their second point of contention on this.
So can you just show me where the respondents talk about Rover in the arguments?
That would be in the outline for respondent.
Yes, Carrot?
Paragraph 3A and B. Team 12. You should say team 12 on the cover paper.
Okay. Go ahead.
Yeah, so as we see at paragraph 3A and B, they have overlooked the fact that Rover Capital would be providing rescue financing and the fact that Rover Capital would be gaining priorities has nothing to do with the effects of the consolidation order. As for their second point of contention on this issue of priorities, they argue that Bridgerton would gain priority given the debt releases, or rather they would Bridgerton would gain priority, but the issue here, or their contention, is with really the effects of the debt releases under the reorganization plan. And we ask this court to view the reorganization plan as separate from the effect of the substantive consolidation, because the foreign representative in this case had submitted two different applications for recognition, one for the order of substantive consolidation and another for the terms of the reorganization plan. And the issue on the debt releases under the reorganization plan will be dealt with by my co-counsel. Now, even if we accept that there is a deviation of priorities in this present case, we say that this does not rise to a matter of fundamental public policy. The respondent draws on the case of Trico, 1997 Southern New York District Court decision, which concerned Bahamian administrative expenses as authority for the proposition that this court can deny recognition and enforcement of a foreign court order on public policy grounds. But we say that reliance on this authority is wrong for two reasons. The first is that Trico stands by itself as a matter of authority. It is settled law that mere differences in the priority schemes of a foreign law does not itself amount to breaches of public policy. And this can be seen by the previous decision of the Southern District of New York in Re Calmer, which also concerned the same issue of Bahamian administrative expenses. But the second and more important reason why Trico cannot be relied on is because it's a decision which predates the model law. And under the model law, the policies or the principles of comity and harmonization are strengthened as compared to the old Chapter 15 insolvency regime. And the general body of model law jurisprudence, such as in Re-Agrocor in the English and Wales High Court, and in ABC Learning Centers in the Third Circuit, have taken an opposite view from Trico and held that deviations from priorities do not itself amount to an issue of fundamental public policy. Now, unless your honors have any questions on my first submission, I'll move to my second submission on procedural unfairness.
Sorry.
Yeah, so for the first point, the relief that you're seeking is a discretionary relief, right, from this court.
Not quite.
It's not mandatory.
Yes, it is a discretionary relief.
Right. And all the fact says that one of the countries where one of the debtors doesn't recognize consolidation and it's against public policy in that country. So how would the applicant be able to enforce these orders? And why should this court grant the order if it's actually not able?
Sorry, can I ask where in the facts does it say that it is contrary to public policy?
Yes, it is actually one of the facts. No, sorry, this is the fact, right?
Yes.
Paragraph 27.
27.
Yeah, it says the implementation of reorganization through control will be a violative of public policy in extra visa. This is one of the better companies.
Yes. Well, the violation of the public policy in extravaganza is irrelevant for the purposes of this present proceeding. The present court is a New Zealand court, and issues of public policy is a matter of New Zealand domestic law.
In breach of public policy of New Zealand. But for the court here to grant that order, exercise discretion to grant it must know that the order would be effective, right? So if the consolidated order is not going to be effective in one of the debtors because of public policy in that jurisdiction, why should this court exercise its discretion to grant that relief that you're seeking?
Well, the principle of harmonization of insolvency proceedings tells us, Rather, the fact that the order was granted in Utopia, which is the culmi of the present restructuring proceedings, and the objective of harmonizing insolvency proceedings, tells us that this court should exercise its discretion to grant the relief, because the aim of Chapter 15 is to harmonize proceedings between the court of the culmi and the court of the courts of the other foreign courts. And so the focus really should not be on whether the order is enforceable in extravaganza, which is not where the restructuring proceedings took place, but really whether it was awarded according to the laws of Utopia, and which we can see clearly took place on the facts. Now, as for your Honour's question, you had a question earlier.
1 minute. It's okay.
And this really ties into my second submission on procedural fairness. And we see that in this case, the court, or rather, there was procedural fairness in the conduct of the Utopian proceeding. At paragraph 23, we can see that Dexter Aviation and Dreamland Local, the creditors, could raise certain objections to the on the consolidation order, against the consolidation order. And finally, at paragraph 31, they have exercised their right of appeal in the Utopian Supreme Court.
Appeal still ongoing?
Yes, and I note that my time is up. If I may have a minute to answer your Honour's question. While the appeal is ongoing, this court can still order relief and recognition of the foreign court order, because this court is allowed to revoke any order it has issued if the basis of the order no longer exists. And this was a point made in the 2024 SICC decision of Garuda International.
Does they make the order first, then if there's a change, you can revoke it?
Yes.
You might as well don't make the order, wait and see what the decision is, then make the order after that.
Well, that may be the case. We say that any time loss would be prejudicial to our clients and to the restructuring process.
But sometimes if you make the order, you can't unwind what has been done, right? If you make an order, other steps might be taken, and you will have difficulty unwinding that.
Certainly. But in this case, we can see that the respondents have taken a vexatious course of conduct. They have brought Chapter 11 proceedings here in New Zealand, despite participating in restructuring proceedings in Utopia. So we say that recognition and enforcement of the order is really necessary to prevent the respondents from undermining the restructuring efforts that are ongoing in Utopia in the first place. Unless I may be of further assistance to this court, then this concludes my submission.
So,
Pastor will go
Go
next.
first, go first. Yeah, thank you. Your Honours, may it please the court. My name is Chester Ong, and I continue the case for the petitioners. I will address this court on the second issue, on whether it is empowered to pass an order on the third-party releases contained in the reorganization plan. So to start, the releases can be found in paragraph 21, specifically paragraph 21E of the facts, where in exchange for the debtor possession financing, Rover Capital and the Flatland Brothers will be released from its past guarantee and surety obligations and nothing further. So this court's task is to determine whether it can order the releases here, since they've already obtained approval in Utopia. And to that end, we make three submissions. First, that this court can do so under Section 1521 of the New Zealand Insolvency Statute. Second, that this court can do the same under 1507 of the same statute. And lastly, that despite the respondent's use of the US Supreme Court case of Purdue Pharma, that the 1506 public policy exception is not triggered in our present case as well. So turning to my first submission, under 1521 of the New Zealand Insolvency Statute, this court can grant, and I quote, any appropriate relief upon recognition of a foreign proceeding. So this also includes the third-party releases in question here, as was done in the US Fifth Circuit Court of Appeal case as was mentioned in the case of Re Vitro, and the later case in 2018 in the Southern District of New York Bankruptcy Court case of Reavanti Communications. There, both courts have mentioned that, with reference to 1521, that the United States courts can grant forms of remedies in Chapter 15 proceedings, even if they may not be specifically available under domestic Chapter 11 laws. And so we see from paragraph 25 that the Utopian Court had allowed for the entire reorganization plan, including the releases. And so at first blush, there is no statutory bar to prevent this court from ordering the releases. So now we turn to whether this court should exercise its discretion in ordering the relief under 1521. So the respondents at paragraph 10 of their written outlines rely on the case of Purdue Pharma to prevent the releases, claiming that if you read 1521 with its surrounding contextual provisions, it must mean that this court in New Zealand cannot recognize any form of relief so long as it involves non-debtors. However, they appear to have put the cart before the horse by assuming that Purdue Pharma, which was a domestic Chapter 11 case, bears any relevance to Chapter 15 foreign proceedings. So the US courts have since thought otherwise, where in the subsequent case of Re Americanas, non-consensual third-party releases were granted upon recognition of the Brazilian proceedings in the Southern District of New York's Bankruptcy Court, even after the ruling in Purdue Pharma. Hence, the respondents have not shown why this court ought to displace the law of the forum court in favor of its own to bar the releases under 1521. However, this is not to say that this court must always defer to the Utopian Court's decision. As noted in the UNCITRAL Guide to the Model Law, there are some breaks to committee and some breaks to 1521, where the domestic courts still have some discretion. As the respondent points out in their outline, the break to committee in 1521 is 1522A, where this court can only allow remedies if the interests of the creditors and the debtors are sufficiently protected. And to show sufficient protection, both parties' interests must be balanced against each other, as stated in the 2006 case of Tricontinental. And we submit that here, the plan protects both parties' interests. Firstly, the releases protect the debtors' assets. A restructuring plan aims to, amongst other things, maximize the assets available for restructuring, and the releases do so by decreasing the overall liabilities of the Fairland companies. So should the releases not be granted, the creditors would go after the relevant third parties. However, the corollary to a guarantee is also indemnification, where after a creditor claims against the third-party guarantor, the guarantor would then in turn have a fresh claim against its principal. And so, from the perspective of the Fairland companies, should the releases, the only way that their liabilities can be reduced is through the releases. Without them, the restructuring efforts will be crippled before they've even begun, and the purpose, which would defeat the purpose of such schemes entirely, as was described in the Hong Kong case of Mutual Group Companies Holding Limited, which also allowed third-party releases. And secondly, the plan at large is also in the interests of the creditors as well. By allowing all of the Fairland companies to operate as a single going concern, the companies in financial trouble, in this case Fairland Aviation and Fairland Local, will be rescued from potential liquidation. And also, this ensures that Fairland Go can also continue supporting the other Fairland companies. And so this allows all of the existing creditors to maintain and restore their business dealings in the event of a successful restructuring. And so we see, once again, at paragraphs 24H and 25, that at the Utopian Bankruptcy Court, the creditors did consider and weigh releasing their claims against the prospects of restructuring, and that at least 75% of them did prefer this option over trying to enforce their claims and establishing new business relations. And so we submit that the plan, including the releases, is beneficial to both parties. Now, the respondents at paragraph 11 of their outline are skeptical as to whether Rover Capital can provide its promised financing, and they cite. And their concern is because Rover Capital has begun Chapter 11 proceedings. However, they've erroneously inferred that this must mean that Rover Capital is insolvent and is thus unable to deliver on their promised $50 million in financing. However, we submit that this is not the case. As observed in Ree Johns Manville's corporation, a company can file for Chapter 11 proceedings without being insolvent. They can do so for other purposes, such as increasing their access to capital or liquefying some of their assets. And we submit that it is for these reasons that Rover Capital has filed for the Chapter 11 proceedings, precisely in order to try and make good on their word, despite facing a liquidity crunch.
But what happens if money doesn't come? Then the third party release would have been already released, right? Money is supposed to come after, right?
If we
Additional funds come after the restructuring, but the releases would have been granted. The third party releases would have occurred already. So then, if the promised money and the plan doesn't materialize, wouldn't the party who had the benefit of the third party release suffer a double whammy?
So your honest concern is that the money doesn't come in and the third parties will be released for nothing, essentially. Well, the facts are silent on how exactly the money would come in, and the highest we can go on the state of Rover Capital's finances is that they have sufficient assets and they are filing for Chapter 11 proceedings. So the highest we can go is that they have filed for Chapter 11 in order to provide their requisite financing. In the event that they cannot, then the most likely situation would be that they would probably have to file for, say, compulsory liquidation under Chapter 7, and then their assets will then go towards
Who's the party that gets the benefit of the party release? I can't remember the name.
the benefits would be Rover Capital itself and the Fairland Brothers.
The party that has the third part, the guarantee.
I see. With respect to Rover Capital, that would be Bridgerton LLP.
Yeah, so Bridgerton used to be able to go after an additional party, right? Because they have this third party claims.
Correct.
But that is now released. And then if they then don't get the funding, seems a bit unfair to Bridgerton.
It would.
When there's no certainty that this plan will actually work. And it's quite often you do a Chapter 11, you try to go in with all the best of intentions, it still doesn't happen, right?
That's true, Your Honor, and that was likely what the creditors would have considered in the utopian bankruptcy court. So all of these considerations on the prospects of restructuring are things that would have been done at the forum court, in this case, the utopian bankruptcy court. And it's our position that they had weighed the prospects of successful restructuring against the releases.
Percent of the creditors actually had third-party releases granted to them, as a third-party, the benefit of a third-party claim.
How many beneficiaries?
How many percent? Because 75% voted yes, right? But those 75%, how many actually have the benefit of a third-party claim? If I don't have a third-party claim, I'm quite happy to vote to say that you can release it because it doesn't bother me anyway, right?
No, that's true. And on the facts, what we have is that we have the 75%, and then at paragraphs 18, we see that the Fairland Brothers, on behalf of the various Fairland companies, had offered personal guarantees to, and I quote, various suppliers. And that's the highest extent of our information here. And we submit that then we invite this court to draw the inference that a sufficient proportion of creditors had approved of the restructuring plan, releases and all. And in any event, even if 1521 were unavailable to this court, this court may also consider granting the releases under the alternative statute of 1507. So under 1507, this court can grant, and I quote, additional assistance, which also includes the releases, as seen in the earlier cases of Vitro and Avanti Communications. And once again, the respondents argue that this is no longer the case after Purdue Pharma, but the same position stands where after the case of Re Americanas, Purdue Pharma should have no legal effect in Chapter 15 cases. And so we turn to the break-on committee in terms of 1507, which in this case is the just treatment of creditors under 1507b1. So just treatment in 1507 is less concerned with balancing the potential financial interests or financial prejudices of the debtors and creditors. Rather, as per the case of Reavanti Communications, just treatment is satisfied so long as the creditors were given due process in the foreign proceedings. And in turn, due process is then satisfied so long as this court is satisfied that the creditors could have exercised reasonable judgment on whether the scheme is in their interests and to reach a sensible decision as to its benefits. And this proposition is obtained from the case of Yuzhou Group Holdings. There, it was held that creditors could exercise judgment on the merits of a scheme so long as they were given an explanatory statement of the plan before voting was conducted. And here, it's our position that from paragraphs 24G and 24H of the facts, we see that at the Utopian Bankruptcy Court proceedings, in paragraph 24G, that the court had ordered and directed a common committee of creditors and stakeholders to be assembled in order to deconflict any issues with the restructuring plan. And then at 24H, that the Utopian Bankruptcy Court would only approve the plan if it reached the sufficient threshold. And as described by my senior counsel, the Utopian Bankruptcy Court sometime later, on January 1st, did in fact approve the plan. So these facts viewed cumulatively lead to our position that throughout these Utopian Bankruptcy Court proceedings, that the creditors had obtained sufficient information to vote as the evidence from the fact that they did in fact vote on the scheme in the end. Hence, given that the factors of due process were satisfied in the Utopian Bankruptcy Court, this court should not face any bar in order to grant the releases under 1507.
It doesn't seem very clear from the facts that creditors were consulted. It seems that the terms of the scheme were just conjured up by the directors and approved by the management, and it's not. And several creditors actually objected to the scheme. So I'm not sure the due process was actually complied with.
Your Honor, I note my time is up, if I may reply. So Your Honor's concerns with due process are similar to that of the respondents, where they rely on paragraph 22 to state that when a plan was first designed, that the design of the plan was confined to the management and the board of directors, and that the creditors were not consulted there. But it's our position that, per the case of Yuzhou Group Holdings, what matters is whether or not they had sufficient information by the time they voted. So even though they were not given the specific details when they planned throughout the construction of the plan, by the time it reached the court and by the time it reached the Utopian Bankruptcy Court, and by the time it was time for them to vote, that the board of directors and management, complying with the court's terms in 24G, would have given them all of the information needed for them to have voted on the scheme in the end. And unless there may be of further assistance, this concludes my submissions. Thank you.
This is just to provide some context. So you can refer to the outline for petitioner represented by Team 10. That is the outline in the respondent. And our outline is outline of arguments for the respondent. Your Honors, may please support. My name is Deputy Hing, and together with my co-counsel, Ms. Meng, we act on behalf of the respondents, Dreamland Locomotors, Dexter Aviation, and Bridgerton. We will each be speaking for 15 minutes. I will address the court on the first issue regarding the recognition and enforcement of the consolidation order, and my co-counsel will address the second issue on the release of third-party claims. Today, we submit that this court should not recognize and enforce the consolidation order, as it is manifestly contrary to public policy on two grounds. First, that the creditors suffered procedural unfairness as they were not consulted regarding the consolidation order. And second, that the creditors would suffer severe prejudice as a result of this consolidation order. Now, in my next 15 minutes, we will demonstrate that this application has not been made in good faith and is entirely self-serving. It forgives 93.4 million worth of personal guarantees extended by the directors while letting them retain control of the group's assets worth 1 billion. Now, even on a broad assessment, this scheme is commercially unreasonable as it undermines creditors' expectations regarding the separate legal personalities of these companies, as well as the plan has no prospect of working. It would likely wipe out the majority of the debt for a mere 15 million debtor in possession financing. And this 15 million forms just 1.5% of the group's assets. And importantly, it is expected to come from Rover Capital, which lacks the means to fund the schemes, as it said that it filed for Chapter 11 proceedings. Despite these alarming facts, the creditors were shut out of the restructuring process and deliberately left in the dark regarding other alternatives for
These creditors voted, right? 75% voted at least, right?
We would say that the facts are unclear if the voting has been done, since it states at paragraph 30 that the court preliminarily approved the consolidation order, and thus we infer from that that the voting has been done.
Why
Now,
do you infer that there's no voting?
we should say that the word preliminarily suggests that this is a pending approval, and a full approval has not been done, has not been given, as the voting has not been done.
Sorry, so it's based on the word preliminarily.
Yes. Now, even if your honors do not accept that and that the voting has been done, we would say that this does not form consultation, as the voting was done after the court had already approved an order of consolidation. Thus, it is already at a juncture that is too late for the creditors to oppose consolidation.
Where does it say voting was done after consolidation?
We would say that it is based on the fact that the court order required that the 75% voting to be done. Thus, it is likely that after the court order, the debtors then had to find ways to conduct the 70% voting.
Well, that voting has been carried out, right? Or not?
Now, even if the fact that the voting has been done, we would say that that is after the directors applied for an order of consolidation. So it is the fact that they were not consulted regarding the consolidation itself that we are concerned with.
But still 75% found it sufficient to pass this.
Well,
How
that,
do we deal with that?
well, that would be on the details of the plan itself rather than the consolidation, since they will not be able to vote on the consolidation since the court had already approved it. And this lack of consultation, we say, can be inferred from paragraph 22, where it simply states that the consolidation was approved by the management and board of directors of the Fairland companies. And later on, that Grant Fairland presented an approval of the board of directors under the Utopian bankruptcy law to commence these proceedings, thus suggesting that the creditors were not consulted on this plan for consolidation, despite it being a key term in the plan. And this meant that the creditors were unable to make a commercial assessment of the consolidation, as the group has not disclosed the projected returns to the creditors versus a segregated reorganization. And we would say that the creditors were not even informed of other alternatives to this consolidation, since it states at paragraph 19 that Dreamland Local offered to take over the management of the board, yet Grant rejected this, suggesting that they did not disclose this alternative corporate rescue to other creditors to at least consider. Now, this is a concern since substantive consolidation is the most extreme measure that the debtors can take, since it destroys the separate legal personalities of these companies and is thus only justified in the most extreme of circumstances. For example, in the case of Snyder Brothers, it stated that the substantive consolidation is only justified where there is such tangling of assets where it is impossible to determine the intercorporate loans or any transactions between the companies, such that it would threaten the realization of any net assets for the companies and the creditors, Thus, only then is substantive consolidation justified.
But in this case, they are quite intermingled, though. I mean, one of the company is paying the debts of the other companies, and we have an ongoing arrangement. So I would say the assets and liabilities are quite mixed together. Wouldn't that justify substantive consolidation?
Yes, and the courts did recognize that, but that alone is not enough to justify a substantive consolidation when creditors made such transaction with the expectation that they were dealing with separate entities. So it would require that the 6 companies were multiple entities within this group were effectively acting as if they were one company that would then justify substantive consolidation, where we are not even able to determine the assets or liabilities of each individual company. Thus, it would only then make sense for a substantive consolidation. While here we are able to identify where are the intercorporate loans made and which function that the entity plays within this larger group, suggesting that they can be restructured independently. Now, thus, it is a major concern that the creditors were not consulted on this consolidation before the directors applied for this order. Now, Your Honours also queried the petitioners on the possibility of imposing a stay on these proceedings rather than to continue with it. And we would agree that this is the most appropriate course of measure that the courts can take, since the recognition is a form of assistance to Utopia, and as the recognizing court, the best way to give deference to these foreign courts in deciding these substantive issues is to allow the appeal to run its full course, and this could save time and cost and allow for a more efficient proceeding. Additionally, recognizing it now would mean that the court is rubber stamping the actions that are causing prejudice to the creditors, allowing the directors to continue the scheme and thus benefit themselves. Thus, we would say that the stay is the most appropriate course of action.
But then that will be on them to apply for a stay of the appeal, right? Stay of enforcement pending appeal. Why should we prejudice the creditors' opportunity to recover at the expense of one appeal that's still ongoing? They can apply for stay if they want it.
Well, we would say that it is unlikely the debtors would suffer any prejudice due to a stay on these proceedings, since it states at clarifications 1 that the debtors have no assets in New Zealand. Thus, there is no urgency to recognize these proceedings here. Versus if we allow the recognition and enforcement of the consolidation order now, it could lead to a loss of time and cost rather than imposing a stay which will allow for more efficient proceedings. Now, this lack of consultation can be contrasted to the situation in re-agricole, where the courts considered multiple factors that suggested how there was procedural fairness and the creditors were accorded their rights under due process. For example, they noted how the creditors participated in the drafting and approval of the settlement agreement. They held creditor meetings in order to allow the creditors to air their grievances, and they ensured that the plan was published on the website to ensure that all creditors had notice before they then voted, and this was then approved by the courts. Now, this can be contrasted to this situation where the creditors were not even aware that the directors were considering an order of consolidation, and thus could not even raise any alternatives. Now, if Your Honours have any further questions on procedural unfairness, we will move to our second submission.
Did any of the clients object to the application for consolidation?
We would say that the creditors have now objected to the consolidation by filing an appeal. And now that
I meant at the time when the application for consolidation was taken, did any of the clients make an objection to the application?
you would say that they were unable to make an objection since they were not consulted, and thus they were unaware of these proceedings to apply for consolidation.
So your clients have no notice of the application?
We would say that they had no notice until later when the order of consolidation was released and creditors then filed for an appeal. Now, moving to my second submission, we would say that the creditors suffered severe prejudice as a result of this consolidation order. And this court can refuse recognition based on the statutory protection that is accorded to creditors through ensuring that the directors adhere to their fiduciary duties. Now, we do note the petitioners have cited the threshold of the public policy, and we readily accept that the threshold is a high one. However, recent case law has shown that public policy has evolved beyond the well-established grounds of procedural unfairness and constitutional rights to consider any fundamental policies that the courts must uphold. Now, for example, in the case of Cumonda, they considered the relief of cancelling licensees in order to relicense them, and considered that that would be against the public policy of ensuring technological innovation, as well as licensees' right under the Intellectual Property Bankruptcy Protection Act. And this was again seen in the case of Retoft, where they considered privacy rights under certain statutes. Now, thus, we would say that the matter of fiduciary duties can be elevated to a public policy, but the courts must ensure that directors adhere to such duties.
So you're saying if there's a breach of fiduciary duty, then it will be against public policy to endorse it.
Yes, especially when it is such a severe breach of fiduciary duties that would lead to severe prejudice suffered by the creditors. Thus, we would recognize that the breach of fiduciary duties would have to be a high one. Now, the importance of fiduciary duties has been recognized in cases such as Gerber Law, where they explicitly described fiduciary duties as a matter of public policy of ensuring that directors adhere to such duties. And under the case or in Retop's holding, it stated that once a group is insolvent, this statutory protection then extends to creditors, where the directors are to preserve the corporate assets for the benefit of the other creditors. And thus, we would say that the matter of fiduciary duties is a public policy because of its fundamental importance.
What if it's a very minor breach of fiduciary duties compared to let's say there's a criminal breach of trust, right? So that's a serious breach. Or it's a more minor breach, like forgot to disclose something non-material. That's also a breach of fiduciary duty, I suppose. So both are in the realm of public policy, against public policy.
We would say that since the threshold is manifestly contrary to public policy, such minor breaches would not fulfill this public policy exception. And thus, we would say that based on the totality of facts here, it already suggests the directors have gone out of their way to put their interests above the creditors, and their actions would lead to severe prejudice that the creditors would suffer. Now, this severe prejudice can be seen for Dreamland Locomotors because it is a creditor of Fairland Go and thus has a high asset to debt ratio. So if the consolidation is ordered, creditors such as Dreamland would suffer. Now,
when you say there's a breach of fiduciary duties by the case of the companies, right? Are these companies New Zealand companies, or are they all incorporated outside of New Zealand?
None of the companies are incorporated in New Zealand. They are incorporated in other places, such as Fairland Go is incorporated in Utopia.
So would you say that the public policy of New Zealand will be engaged if the breaches were by directors of non-New Zealand companies?
Well, we would say that this court would be allowing such breaches of fiduciary duties by enforcing this consolidation order. So it is a matter of principle that the courts must uphold interests that are fundamentally important.
These are not interests of New Zealand companies, right? So there's no engagement of New Zealand public policies.
We would say that despite the lack of effect in New Zealand itself, it is still a matter of principle that the court will want to ensure that they are not allowing or condoning actions by directors that would cause breaches of fiduciary duties. And thus we would say that this court can consider these breaches within the public policy exception. Now, in terms of severe prejudice that the creditors would suffer, this can be seen in Dreamland since it is a creditor of Fairland Go, where it states at paragraph 19 that it has a profitable business and is thus likely asset rich. Now, this can be contrasted to Fairland Aviation, where it is likely to have little assets. In that paragraph 15, it stated that it struggled to meet its capitalization requirements. Now, Your Honours, I know that my time is up. If I may have 1 minute to wrap up this severe prejudice. Much obliged, Your Honours. Now, because of that, because Dreamland is a creditor of Fairland Gold, if a consolidation is ordered, it would lose out since it is a creditor of a high asset to debt ratio. Now, this can be seen in the case of Snyder Brothers, where they acknowledge that consolidation will always lead to that separate debtors will always have differing ratios of assets to liabilities. Thus, creditors of debtors whose asset to liability ratio is higher will always lose to the extent that the asset to liability ratio of the merged assets will be lower. Thus, we will say that Dreamland is likely able to claim back only a smaller amount of the debts owed to it versus without a consolidation order. Now, this is not the only severe prejudice where there is a substantial risk that the plan may not succeed, as only 15 million will be provided as cash injection, yet the total debt is estimated to be about 21.2 million. Now, this can be seen from the fact that debtor is owed 1.2 million, as stated at paragraph 16, and supply arrangements for Bridgerton for a duration of 5 years at paragraph 17 is likely to amount to an estimated 20 million. Now, we estimate this amount from the 12 million that is suffered from 2020 to 2022. Now, coupled with the fact that it states at paragraph 35 that Roper Capital was in a liquidity crunch and thus filed for Chapter 11 proceedings, there's a concern that these 15 million will even be provided. And even if this 15 million could be provided, it is insufficient compared to the total estimated debt. Thus, there is a substantial risk the plan may not succeed. Now, unless your honors have further questions, this concludes my submissions. Thank you.
Your honors, if I may begin. Your honors, may it please this court, I'm Shermin Ao, and I'll be comparing the case for the respondents. I'll be speaking for 15 minutes. Following the consolidation plan as laid out at paragraph 21 of the facts, such non-consensual third-party releases of Grant Fairland, Gem Fairland, and Rural Capital cannot be granted and empowered by the court today. I'll be addressing 3 main issues. First, the present third-party releases are non-consensual, and second,
What was voted on?
it was
75% vote for the plan.
no, as what was emphasized by my co-counsel earlier, we are of the position that 75% approval has not been obtained. And
So they voted after the consolidation, but they did vote, right?
they did vote, but
So why do you say it hasn't been obtained?
we say that it hasn't been obtained because for the third-party releases to be deemed to be consented to, it needs to be noted that affirmative consent has to be given by the creditors.
And how would that consent be given?
Regarding how this consent would be given, it's our position that third-party releases can only be considered to be consensual and permitted if adequate notice has been provided, and this has been affirmed in the 2009 Second Circuit case of In re DBSD North America.
So you say there's no adequate notice here.
Yes,
So you're saying notice was given, but if it was not enough time to look at it, or not enough notice given, or not enough facts given.
it's our position that with such factual uncertainty, no notice has been given to the creditors regarding the third-party release provision specifically. Because what constitutes adequate notice is that the creditors must be provided with clear instructions on how to opt out of the third-party releases and must have been given the opportunity to mark their ballots, for example, if they wish to opt out. However, nothing on the facts points to any of such evidence regarding such a process even happening in the first place. And this proposition was upheld in the 2013 US bankruptcy case of In re Indiana Police.
So you're saying for voting, I must actually say, oh, you can opt out of this. I must specifically say that for third-party releases.
Yes,
And if I say, I don't tell you to opt out, I say, here's the thing, it's a third party, you can vote yes or no, and that's not good enough.
yes. It's our position that consent to the reconsolidation plan does not necessarily mean that the creditors have consented to the third-party release provisions.
Are those provisions inside the plan?
Yes, it's indeed inside the plan. However, as what was affirmed in the 2009 Second Circuit case of Hing v. North America, an extra and explicit consent must be given specifically to the third-party release provisions too, especially for those creditors that are deemed to be bounded by such third-party releases. However, nothing on the facts points to any of such evidence, or if such notice or process was even provided in the first place.
So you're saying because it's such draconian release, the effect is so wide-ranging, you need to highlight it to your creditors so that they know about it, so that they can say yes or no to it.
Yes.
And that wasn't done here.
Yes. And as further emphasized by the case of Hing v. North America, the court held that those who had voted and deemed to have opted out of these third-party releases will not then be bounded by these third-party releases. However, Your Honours, if I may refer you to paragraph 39 of the facts. It must be highlighted that the foreign representative admitted that the current issue here was regarding non-consensual third-party releases, as can be seen at the last sentence at paragraph 39. Therefore, it's our submission that even on the merits, the third-party releases are also deemed to be non-consensual due to the lack of any adequate notice being provided here to the creditors.
So, sorry, what does the last sentence show?
The last sentence shows that the foreign representative deems that the present third-party releases that is of issue here in New Zealand is deemed to be non-consensual.
Not deemed, but is non-consensual.
Is non-consensual, yes. Next, I also like to address how the petitioner has misconstrued the case today by arguing the cramp-down measures as can be seen at paragraph 20 of their written outline. It's our position here that cramp-down is not an issue that the court is concerned with today, and we have also already established that these third-party releases of issue here are non-consensual. Therefore, by arguing for such a measure, the petitioner here has assumed that the court in New Zealand today is the lex fori to make substantive orders to cramp down. However, this is untrue, as our present proceedings concerns more of recognition and enforcement of orders instead. And there have also been no circumstances in our case where cramp down has been exercised. Turning to my next submission, it's our position that the third-party releases cannot be granted under Section 1507 of the New Zealand Bankruptcy Code. Section 1507 governs the principle that a foreign remedy will only be granted if the recognizing court has granted it domestically. Therefore, as our present proceedings are to be decided in New Zealand today, it's our position, and we would like to emphasize that the US domestic law is relevant and applicable. And here, we would like to refer to the US 2024 Supreme Court decision of Purdue Pharma. The question is whether Purdue Pharma poses as a limiting factor in giving effect to foreign law that differs from the US domestic position. However, since Purdue Pharma was silent regarding applying such a holding in the Chapter 15 context, it is our position here that the court today should not be hesitant to apply its holding that the bankruptcy code will no longer authorize non-consensual third-party releases in the Chapter 15 context today. This decision should certainly be upheld, as it will pave the way in striking down previous cases that have been employing non-debtor releases in facilitating fair and equitable recovery for victims.
Victims?
Apologies, for creditors that have been prejudiced. Moreover, such holds valid policy considerations in ensuring that the creditor's interests are being protected, as well as to prevent non-consensual third-party releases from acting as an instrument for wealthy individuals and corporations from using it to misuse the bankruptcy system without placing much of their assets on the table for distribution to the creditors. Further, the holding in Purdue Pharma regarding its definition of debtors must also be emphasized, because the court held that one can only be considered to be a debtor if they are the ones that have filed for bankruptcy, and also have placed virtually all of their assets on the table for distribution to their creditors. And such a strict interpretation of debtors must be upheld, since Chapter 15 only operates for the benefit of debtor and not any other entity. Here, it will be apt to analogize our case with Purdue Pharma. And in Purdue Pharma, the settlers in that case were closely related to the company as directors and officers of Purdue Pharma Company. And the Purdue debtors then proposed a Chapter 11 reorganization, which consisted of an establishment of a victim compensation fund where the settlers had to contribute $6 billion to it. And the issue here was regarding whether such non-consensual third-party releases that was part of this plan can be deemed to be granted by the court or not. Here, the court did not empower such releases because the settlers in this case were not considered to be debtors, as they did not file for bankruptcy and also did not place virtually all of their assets on the table for distribution to the creditors. Yet, they seek to pay less than the code ordinarily requires, as well as receive more than it normally permits. Therefore, it's similar in our case here because Grant Fairland, Gem Fairland, and Rover Capital cannot be considered to be debtors, but instead third-party guarantors. Because firstly, they did not file for bankruptcy and were also not part of the foreign proceedings here. Second, they were also not part of the reorganization plan to restructure the Fairland companies too. Hence, such third-party releases here cannot be said to be necessary, but rather entirely self-serving and prejudicial to the creditors here.
But that's the whole purpose, right? You are releasing a third party, so they don't have to be a debtor. And that's the whole idea behind it, because if you don't release it, then the plan won't work.
Yes,
But you seem to be saying they must be a debtor in order to be part of the plan.
yes, this is because under the Chapter 15 proceedings, third party, the Chapter 15, Section 1507, for example, here at issue, only seeks to grant the third party releases if it benefits the debtor and not any other entity. And hence it's our position here that Grant Fairland, Gem Fairland, and Rover Capital would be deemed to be third party guarantors which will fall under any other
They're
entity.
not deemed,
And
they are guarantors, right?
yes,
I don't think there's any, right? They are guarantors. They don't, that's fine, but I just don't understand why your proposition seems to be they must be considered debtors in order to be bound by the terms of the plan.
yes, debtors in the case that they must fall under the debtor's definition as highlighted in the case of Purdue Pharma when they were considering the third party releases.
You see, the words itself tell you that they are third party. That means they're not a debtor, they're not a creditor, they're third party. And that's why we allow the release so that the plan can go through, because otherwise the liability is so large that, or else maybe they were not refinancing or something, some other reason the plan will fail. And there's a benefit to that, right? So you were saying that under Chapter 15, they have to be a debtor, otherwise they cannot be released, right?
Yes,
Here it's not Chapter 15, right?
it is Chapter 15, as can be seen at paragraph 40.
The application is by the debtor companies to seek recognition of the plan of organization that was granted in this Utopia, right?
Yes,
So it is not an application by the guarantors to enforce that party release.
yes,
Right?
and
So the benefit is to the debtor companies to enforce the scheme which has been passed by 75% of the creditors.
however here, if we were to grant such third party releases, the third party guarantors here, the three parties, would be benefiting from these third party releases at the expense of the creditors. Therefore, it's our position that that's why these third party releases are self-serving, especially to Rover Capital.
But in this case, the debtor is also benefiting. It's getting the 15 million debt financing in consideration for the releases. So it's not just the third parties guarantors that are benefiting, it's the debtor also. Ultimately, it's a scheme, it's a plan for the debtor.
So just because the third party benefits doesn't mean it's not fatal if there's also benefit to the debtor, right?
I understand your concern here, Your Honours. However, it's our position here that if this third-party releases, even if it could be said that it will be benefiting the debtors, however, this is at the expense of the creditors because the cash injection of $15 million cannot be considered to be good and sufficient consideration. And here we turn to section 1521 of the New Zealand Bankruptcy Code, where it must be noted that in recognizing such a release under section 1521, this requires the application of a balancing test under section 1522A, which must ensure that the interests of creditors have been adequately and sufficiently protected. This proposition has been affirmed in a 2005 US Court of Appeal case of In re Metro Media. Here, the $15 million cash injection that was promised by Rover Capital in exchange for the releases is not substantial. Firstly, there is no explanation as to how this injection will benefit the plan, because this cash injection could be said to be merely acting as a bridging loan in the current debtor in possession financing scenario. And this injection procured by the directors is also not sufficient to compensate and allow them to be forgiven for the total personal guarantees of $93.4 million. Furthermore, this mere $15 million cash injection also pales in comparison to the total debt of $143.4 million. Second, there is also no clear indication as to how this $15 million will be obtained. And as can be seen at paragraph 35 of the facts, Rover Capital is also currently facing a liquidity crunch and have also filed for Chapter 11 proceedings. This certainly raises doubts as to whether they have the financial capability to provide further for this debtor in possession financing scenario. Therefore, with the interest of the creditors needed to be considered as a whole, it can be seen that the third-party releases here are indeed self-serving and prejudicial, as the third-party guarantors are benefiting at the expense of the creditors with such third-party releases being granted and included in the reconsolidation plan. Unless I may be of further assistance, this concludes my submission. Thank you.
There's 2 minutes, Robert. Your Honours, 2 points in rebuttal. Firstly, in response to Your Honours' query on creditor approval, the respondent argues that there was no consultation or voting that had been done after the consolidation was created and granted and approved of at the Utopian Bankruptcy Court. However, the respondent is simply attempting to relitigate the merits of the claim here by claiming procedural unfairness. 2 of their clients had also, before the Utopian Bankruptcy Court proceedings had even taken place at paragraph 24, they had already raised objections to the application, and we can see this at paragraph 23, where an interim application was made by Dexter Aviation, and Dreamland Local had also sought an injunction against the consolidation. So it cannot be that by the time the Utopian Bankruptcy Courts had addressed the matter at paragraph 24, that they still had no notice of the plan. So it cannot be that there is procedural unfairness on this issue. Second, regarding the second issue, Your Honours were concerned with how it could possibly be that third-party releases must be categorically refused in Chapter 15 proceedings just because they involve a non-debtor. So that is the respondent's position mirrors that of the case of Purdue Pharma, which firstly was a Chapter 11 proceeding, and so should not, at first blush, bear any relevance to the present case. But regardless, the respondents claim that the policy considerations at Purdue Pharma mean that it is transplantable from 15 to 11. But we submit that it is not the case. Purdue Pharma had categorically banned non-consensual third-party releases in Chapter 11 proceedings because they were concerned over creditors misusing Chapter 11 where in order to escape from mass tort liabilities or claims against fraud and negligence, they would have a third-party release that is so broad as to cover those claims. But here, there is no such thing. The third-party releases here are limited purely to past contractual obligations, and we submit that such limited releases are entirely consistent with the purpose of Chapter 15, which is to ensure the fair and efficient administration of cross-border insolvency proceedings. Hence, any reference to Purdue Pharma is irrelevant to our current proceedings. Unless I may be of further assistance.
But for that point, if Purdue Pharma is persuasive, but it's not binding for this court, right? And if we follow the decision in Purdue Pharma, then wouldn't we grant this application? We will be creating a situation where this court would have two different positions in terms of policy, in terms of third-party releases for this country.
Yes, so what would happen, Your Honor is correct, what would happen is that in Chapter 11 proceedings that non-consensual third-party releases cannot be granted, but it can in 15. While this may be unusual, we submit that that these two positions are not in conflict with each other. So
but the underlying policy reasons should be the same. It relates to third-party non-consensual release. The mode of the way that the relief is sought is via Chapter 11, Chapter 15, but the underlying policy should remain the same, should be consistent.
Well, it's our submission that the crux of the matter is, does the remedy sought for fit in with the purposes of its respective chapters? So Chapter 11 is now barred by Purdue Pharma because they claim that any sort of these releases would lead to misuse or malfeasance on the part of third parties, and so they cannot be granted categorically under Chapter 11. But the difference between 11 and 15 is that at 15, the principle of comity comes in at 1501, where we see that where this court can be taken to respect a foreign judgment, that at the lex fori there has been no such malfeasance, and that their court's proceedings and that their court's tests of fairness or breaches of fiduciary duty and so on have all been satisfied. And so when that case comes over in the Chapter 15 proceedings, for us to recognize that this court is free to do so because there is already all of these underlying policy considerations would have already been dealt with in the foreign court.
Yes, correct. But under Chapter 15 application, exceptions to comity will be the public policy of the recognizing court, right? And if the policy reasons underlying Purdue applies here, wouldn't that be an exception to that to comity?
Not necessarily. So in brief, 1506 public policy considerations is a high threshold as discussed by the senior counsels. And there something is only manifestly contrary to public policy if it is a breach of, say, a fundamental constitutional or statutory right. And we submit that these differences in what remedies can be granted do not rise up to that threshold. Unless I may have further assistance. This concludes the reply. Thank you.
Yeah.
That decision. So I think there's something that consideration we should want to consider. That's not sufficient.
To add on to what we said, for example, for the petitioners, I think, no, for the respondent, it will be on the point of getting creditors' approval. I mean, practically, it's very hard for the court to approve a plan or a scheme without first checking whether creditors have approved it. But I understand the facts are quite silent on it, and it's quite arguable in both cases. But I think you have to be prepared to address the situation where, okay, let's just say creditors' approval has been obtained. Then how do you then go on that basis and make your argument as the respondent? How do you say, oh, the court should favor the dissenting class of creditors, and it's the prejudice is so much that it is not it's so much that just because 75% approved it doesn't mean that adequate protection has been granted.
So I actually did individual comments, which I normally do for moods. I thought that, okay, let me start with Ryan. You were very like,
Yeah.
so very newsreader like. And I'm not sure how it's going to work because it's a Zoom thing, right? And do you just look at one? If you have a bench, you look at 1, 2, 3. You always move around and make sure you are watching the bench. But if it's a Zoom, how is it like? There are 3 or 4 of them pop up, is it?
We just look at the camera.
Just look at the camera.
Gallery
Okay.
view like that.
Okay, so you I didn't really practice that with Zoom, how that looks, because it was very newsreader like, and maybe for me, personally, I prefer a more engaging style in the sense of like, yeah, I'm talking to you, rather than I'm reading my stuff to you, which
Yeah.
was a bit of the sense I got. So that's in terms of style. I felt generally on your presentation, there were a lot of kind of like comments made, but I didn't get the facts. Like you didn't come and tell me why it's so important to you that the court goes ahead and makes the order now. What is the prejudice to you? I mean, you use the word as prejudice, but what is it? What exactly is it? So, for example, if I contrast it with these guys here, they came and say the debt is so much, and then they want to release so much money, and then they only pay so little, right? Then I have a comparison between how much money is being released, how much money you're putting in. Oh, it seems very unfair because the numbers are there. So I felt that if you could throw the facts more at me, that would be good. Like, what's the prejudice? Like, what actually is a prejudice? Oh, it's not done yet. And then no, what real bad thing happens if you drill it down to basics? So like, for example, I think you asked a question about using enforce first, and then you can always unwind.
Yeah.
Right? Yeah, so that's very dangerous. Now, once you make an order, sometimes it's then if everyone acts on that order, how do you unwind it?
Yeah, that is true, but at the same time,
So you can't even entertain that,
yeah,
You have to say the appeal is going on. I don't know how the appeal
I think
affects you.
maybe we can say consolidation is sort of like theoretical. Like so they talk about how the assets and liabilities will be pooled, right? But it's not like the companies are gonna start operating as one entity, right? The pooling will only have effect in a liquidation scenario, and we are in a reorganization.
So why so important to make the order now?
I guess maybe it's because the respondents are bringing a lot of duplicate claims, claims that have already been decided in different jurisdictions. So maybe we should just get out and recognize it.
To say that, you need to say like, we've already done the thing, we've consulted with people, we've given people a chance to vote, they've done all of that already, and then we need to get on with our lives. But if they keep suing us, we already have limited resources if that's the case, and yet we have to go and entertain all these other things. Some of them are bogus claims, and we need finality, we need to move on, something like that. But using the facts. So I think for you guys, if you have more facts there, they help. But otherwise, it's very difficult for me to be sympathetic to you guys, because it does seem as if you're just wearing it down.
Another one, use the facts to your advantage.
Yeah.
To build on to it. So like you can say that, oh, their clients have this there, over there, therefore they cannot complain now.
Yeah. What are the consequences of not proceeding? For insolvency cases, right? It's actually very practical. You're using the law to try and deal with this group of people, all with different rights, different obligations, and different reliefs, and then you're trying to make it somehow fair. And nobody really walks away very happy, because everybody has to take a bit of haircut here, has to suffer a bit there. But generally, if everybody suffers a little bit, then it's still better than one person suffer very badly. That's kind of how it works, right? So you kind of need to say, but that's when you have to talk about how it will affect you, how much you will suffer if you don't get this. And that one, I think you need to roll it off your tongue more quickly.
Okay.
Okay, and then don't look so much newsreader. I mean, you look very good, okay, but very newsreader. If your aim is to be newsreader, you nailed it. Okay, but this is a mood, and always in moods and you are talking to the judge. So you want to be engaging with the judges. Chester, I thought you're very good in terms of engagement, a bit more lively, which is good. I don't know what the answer is to the double whammy question that I had. Is that a valid question? I don't know the facts so well.
I mean,
so
like,
as
if
you
the,
know.
I mean, it's a fair question, right? Because now it is suspect whether it is suspect whether,
11, it's like chapter 11, you are in trouble already, right?
yeah, like you're already in some trouble. So like how to say,
Then that, oh, it's not in trouble. I mean, nobody voluntarily goes through a chapter 11, unless they need to.
yeah,
So you downplay that,
as in the difficulty is that because how to say, the first instinct is with the responder, right, that Rover Capital has no money. Then the only viable response is that they are trying to scrounge money up from somewhere, and they've done so by restructuring under Chapter 11. Because I believe compulsory liquidation is 7, right?
Case to say that those 75% who voted, and if you can say a large percentage of those also have third-party benefits, which they're prepared to give up. So rational commercial people will not vote in favor of something unless they really think there's a benefit to them, if they are also giving up something.
So it's better to say it's better to refer back to the yes, all of these considerations are valid, but all of these considerations were already done at the Utopian Bankruptcy Court.
I'd say that because that means the 75% who voted also had to give up third-party guarantees, but they were prepared to do so because they think that overall they get a better benefit under the scheme or under the plan.
Okay.
I don't know whether your facts support that or not.
Unclear.
Yeah.
But okay.
That would be better, I think. Yeah. And then I think you also said like the creditors were consulted. I have this comment to say too general, no numbers. Like again, it's a statement, creditors were consulted or something like that. And I'm like, yeah, what are the details? So you want to say we gave them A, we gave them B, we gave them C, then how much time, they thought about it, they asked this question, if possible. So again, that's use of facts. So that tells me somebody, I think for insolvency law, you have to have this fairness thing down, if everyone is in a shit position, but if you have time to think about it, ask questions, do something about it, then you can't complain that it's not fair to you. But I need to know what exactly was it. If you just tell me consulting, I can give you 1 day, I can give you 1 week, I can allow you to ask questions, or I can say no questions asked. So you have to tell the judge more what the facts are.
I think the difficulty is that
this is not very well done.
because I think what would have rescued us is I mean the biggest complaint is a date. If paragraph 4 had a date attached to it, would be quite helpful, but there isn't one.
Let's can some more each paragraph. Instead of looking at each line, how do you read it in at least 50% credible way?
Because I think all we have for petitioners in terms of actual due process is I think 24G and 24H, and that we now have to infer that some time has passed between 24 and 25.
I don't know the facts well enough. Do you know? We come up with some fancy argument.
There's nothing on the facts that creditors were consulted. And it seems to me that 24G just says approval must be obtained. So it's a future.
Yeah.
Yeah,
because our current position is like some time would have passed between 24H and 25, and then this would be the appropriate time period. But the difficulty is that there is no the only timestamp we have is 25 and not at 24. So the highest we could have taken it so far is like an inference that some time has passed, which is our current difficulty.
A way to say the plan was passed in their own jurisdiction, right? Right, vote was taken that there's no reason to think that there's no procedural fairness there, that public policy concerns are not respected there, that they don't do things properly there. So you don't second guess what happened there.
Oh, I see.
And you said the facts are not clear, right? So it's better on them, right?
Yeah.
Because if they say it's unfair, they have to show you why it's fair.
Yeah. So I'll start, and a lot of judges are like that. I don't want to say bad things about another jurisdiction, right? And if that jurisdiction is also a mature jurisdiction, then we take it that everything was done properly,
Okay.
and they cannot say what was not done.
Okay. So lead in with the like, oh, we don't want to disparage the Ethiopian back to Singapore. Okay.
Principle of what committee
Okay.
is quite an important principle, and that's also part of the whole model law, right? That we don't second guess each other.
Okay.
So we make use of that.
Thank you.
I think don't say it the highest we can give, because it's like it sounds so apologetic, like, oh my God, I have terrible facts, so all I can do.
Okay.
I think you don't want to say that.
Okay.
I don't think you can make something out of this. It's quite a lot of money. So this is obviously a big case, and there must have been proper consideration given to all the issues at hand by the courts in that jurisdiction. And then I don't know whether there's enough numbers there to say how many creditors. No, right?
No, we have the named creditors and various suppliers, and that's it. But okay, I think we can.
Look at the kind of industry is in, then obviously it's like, if I tell you I'm a car manufacturer, you're not talking about a small company. There's a big plant, there's lots of people. So implicit in that is there's scale, there's volume. What is that? Aviation, yeah. Right. So it has to be a lot of suppliers. I mean, just naturally, what are suppliers for athlete? So many parts to be supplied. So it is definitely a large number. Yeah, I thought your rebuttal was good. Were you the one who also said Purdue Farmer was before model law? No, right?
No.
So did somebody say that? I thought somebody said that.
I don't think so.
No, but it's not. The date is not. So
No.
He dated model law.
yeah, right?
Oh.
Say that?
Not Purdue.
That was in relation to a different point.
Which case?
Trico.
Oh,
It's a priority thing.
yeah, I heard that. Okay, that's all I have for them. So you guys have the more difficult case on the facts, right? Okay, Stephanie, I thought you were very easy to listen to. I like the style. And I thought we used the facts much more effectively. Like, we kind of say, wow, they did so many bad things, and then they want to pay us off with so little money. I mean, come on, how is that fair, right? The breach of fiduciary duty point was difficult for me. I don't think it's if you have more case law to say why it should be public policy, I think that's important. And you want to come out and say, oh, we're not talking about any type of breach. It has to be very egregious breach. And I wonder whether you can say that here is almost like a fraud on everybody, These guys just go off and do their own thing, and it's a blatant disregard of what they're supposed to do. And then they want to buy us back so we can money. This is not just breach of fiduciary duty, it's something even more egregious than that. And think of some kind of wording to use. They are really pulling a fast 100 creditors. And there's just some fundamental unfairness to it all.
We build up on unfairness, right? Things like you guys, the creditors were led on to this, right? Given these guarantees for you to continue incurring liabilities, and then next round you pay away my guarantees.
Yeah, how is that fair? Right? Yeah. All of you will benefit from using the facts a lot more. Yeah. For the debtor side is always, I really need this, I need to complete this, otherwise I'm going to die. And when I die, how many people will die with me? So therefore I need to do this now. How many workers you have in the civil aviation? It's not going to be the hundreds, it'll be the thousands of people. They need to be able to move on. Then for you guys will be like, oh, we helped them, we gave them, we trusted them. Then look at what they do for us now. So the way you put it was very good, right? Like, you string me along with guarantees, anything you take it away from me. Right? Then I will also die. So and you're pulling on the heartstrings of the treasurers. I thought for you again, use of facts, like what was given to the I thought every time we asked a question, you kind of answered with some law or case that was very long. And then you gave me what the case said, and then I got a bit lost after that. You may want to see if you can practice really answering the question much more directly. Always think about, if you ask a question, yes or no, think of that first. Yes, no, because this. Yes, no, because there's a case that says this. Then here's what the case is. Yeah, I don't know. That was my. Then I had. Yeah, this thing about third party release, you must highlight and bold and give people a chance to opt out. Is that correct? I don't know the law of that.
Like we consulted our coach on that, and then she said, yeah, like in practice, then there needs to be like a separate consent for third party release.
We don't do that, what, do we?
That's the thing of it, I vaguely remember.
Is it? But the ones that we did last time, we didn't do that. So we definitely had done plans with third party releases. It's just a term there. You can see it. We don't hide it, but we don't. It's very unusual to put the burden on us to make sure that, hey, you make sure you see, I go and highlight for you, you know?
I think it's more about whether they were given the opportunity to opt out and were given like detailed instructions on how to do that.
But if you can opt out, wouldn't your scheme be like a different scheme maybe? Then this is a separate class. Is that a class issue there?
Currently our facts here, there's nothing on the facts to show that the creditors have been classed.
I know. So they said they're all on class,
Yeah.
right? But if I can opt out of something, that means the benefit I'm getting, what I'm receiving under the scheme is different from those who are inside, right? Who have not opted out. Might not that be a class issue?
Well, actually, yeah, right. Because that would be what happens in what's there, re-Americanas also, where if you agree to the releases, you'll get more cents on the dollar that you don't.
So the point is that there's no consent, like there's a law says you cannot take away the rest without the party's consent. So that they didn't.
As in, you're saying that's a better argument than opt out, right? Because opt out, I think, brings with it this problem of class. If they, well, I think it's not bad for you because if they can opt out, then you have a class problem, then the scheme cannot pass with you. I mean, it leads on to another issue, but I think this point is maybe attacking it on consent is better, but 74% did vote yes, right?
Yeah, because initially when we first started, then yeah, I did run the consent argument, but all the judges point to paragraph 25 of the facts, which to say that actually 75% has been obtained. Like it's quite clear because the court has approved it.
So the question is whether team consent is sufficient, whether 25% really consent. Whether by way of statute, that's team consent, does it keep within the requirements of consent for party?
Pretty much, right? But then like the trouble with this is that what is consent, at least in the US, is quite murky. Yeah, like deemed consent is difficult, and then it's split on the what's it called? It's split across the circuits. What constitutes consent?
Don't like the word deem, because deeming something means it didn't really happen, maybe it happened. It's just so like iffy, you know. If they were given a copy of the scheme and they have voted on it, we take it that these are all adults, they are all companies, they know how to do their own business, and they would either say yes or no. And if they say yes, they say yes, that's it. What more consent do you want? So then if you're saying that consent is not good enough, we need to say why it's not good enough. Yeah, so here they're reading it because the bankruptcy court ordered the consolidation and approved the plan. The implicit in they approved the plan means that creditors must have voted in order for the court to approve, is it?
Yeah, like our past judges say that due to this paragraph, it cannot be said that 75% of people has not been obtained. Yeah. That's why we are running the argument that there wasn't any affirmative consent given to the third party releases because there needs to be an opportunity for the creditors to opt out, but nothing on the facts clearly states that any such process happened.
I think so, but that consent like for taking away like the party release, right? Is it a general consent or is it the person who's might have taken away the consent?
The creditors own.
So on the fact there's no indication that you can take it.
Yeah.
Right. So if you're arguing that you shouldn't grant that, then that would be in your favor. Instead of the fact that no evidence that the party is consent, and therefore you going to into the question for the court to grant.
I don't understand.
In order for the court to grant the release, you need to show that the person who's right is going to make it. For the check, there's no indication that those affected person is that.
For 75%.
You only 75%, but you don't know whether 75% includes the people whose rights are taken away. Or would that those people all be 25%?
You don't know how many had the benefit of the third party.
Yeah.
So, but if you're arguing against that recognition, then it's for them to go and say there's no evidence that those people are represented, and therefore, how would this court be satisfied with everything now?
Yeah, then
That was what I was trying to say with the affirmative consent argument. But
But you got on the facts, so it's clearer.
yeah, that there's nothing on the facts that shows it.
In paragraph 39, I thought you're not sure about paragraph 39. Or the last sentence. I don't understand it.
Yeah, because the applicant, the opposing team that are going to do, they are arguing for they are arguing both sides, like both consensual, and then if it's not deemed to be consensual, then we can clamp down the creditors. Yeah, so that's why I started off by saying that here our issue here is regarding non-consensual third party releases. So then like giving all the other arguments for whether it's consensual or not will not apply here, and that's why the clamp down will also not work. Yeah.
I think on both sides.
No, I'll be arguing for responding.
And the particular is saying that there's a clamp down
Yeah, they're arguing for a clamp down measure.
in the chapter 15 application.
No, they are using chapter 11.
But that's not a chapter 11.
Yeah, this is not chapter 11 case. That's why I'm using that to go against it.
Wouldn't that be just something that this is a chapter 15?
Yeah, the opposing team is just wrong in law for this one. Like they're flatly wrong in law.
It's wrong, right?
But answering quickly and to the point, what you want to say is they just got it wrong. They are saying clamp down, but they are wrong, and they're wrong because this is the wrong application, right? Whatever. But say it like that, then because otherwise it takes a long time. I feel that you tend to want to give the substance of what you want to say, but you are kind of the headline is here, but you want to give the parts here. You must headline first, headline. Okay. Signpost, always signpost very important. What I have. So maybe what I'm doing is really I know it's not very good, but see there are ways that I think all of you actually need to sit down and need to say these facts, I think we can find it this way. And look at it from all angles and say, I think it's possible. Like the one that you had was a preliminary. Seems like a lot to hang on one word, right?
Yes. And some judges have interpreted it as approval pending appeal.
Yeah, it can be so many things. Like I approve first, and subject to you serving this on everybody or commission to courts, and then it becomes final. That could also be possible. So it's like, is that the only argument you have?
For R, yes.
My own sense is when you use facts and say this fact is for me, it's very useful. But you use this to say that there's no consent, right? Or there's no vote. Yes. Which is a big thing. And when you want me to accept your factual position based on this one word, to me, it makes me not want to trust you so much because you're like, okay, So you kind of want to be credible in the positions you're taking. Because if you yourself cannot hand on hand and say, this passed my own smell test, not going to pass the judges. And then they're going to say, I better go and check what this guy is saying. Yeah. I'm not sure that you make the argument that they will hold on.
Yeah, that's why we bank a lot on the public on the argument.
I think then you might want to just go into a bit more the heartstrings, third party release the third party guarantee was so important, so critical. How the courts treat third party guarantee, you're really taking a huge right away. And then you use that double, and you think, like what if is nothing comes in? Now I'm left with nothing at all. And then this what he said about leaving down the garden path. So you kind of talk about the importance of third party releases, and then you kind of say, look at what they're doing to us here now. Without even getting everybody to sign on, the actual parties who are going to be deprived of this to confirm that they agree to it, then the court just take it away. I think we have to go on the policy about the first. We establish that's so important, and then look at what this plan does to the party. Look at how they derogate all these rights.
I think one concern is also, I'm not really sure how to actually use Purdue Pharma because
It's be useful for you, right?
yeah, it's useful, but Purdue Pharma is a Chapter 11 case, so many judges will be like, oh, why are you using Purdue Pharma? Like, how is it relevant in the Chapter 15 context? But because like the case is so new, so there's nothing, I can't really find any articles to like show that Purdue Pharma's decision can apply the same Chapter 15.
What's so different between an 11 and 15? I know 15 is your recognition or whatever, right? But what's so fundamentally different about it?
I think 15 recognizes community, so
So this is what I'm trying to
yeah.
The
review, right?
difficulty there.
The principle of the public policy is the same, right? Whether it's 11 or 15, it cuts across something that is not right. And if Purdue says it's not right, then that same wrong can be recognized in the 15 case. And then you use the exception to public policy, right?
Yeah, but I think what is the problem here is because Purdue Pharma is a mass not bankruptcy. So compared to like our case here, like some judges were like, but our case is not doesn't go to such a high level of mass not bankruptcy. So Purdue probably decided that because it was so egregious.
It's quite egregious here. You need to say that our case here is just as egregious.
So but fundamentally, it's taking away of right of the creditor, and without, which is too extreme.
So when we were in law school, we always go on legal principles because that's what we're learning and we're so into that. But actually, when you go to court, right, a lot of times it's the facts. It's the facts. You are coming to court, you are representing the small guy, the little suppliers who maybe family-run companies, supply, suddenly now they are like knocked down, And you're the big aviation company, you're the big guys, how much you earn? Probably $30-40 million a year. And now you want to write rush off over us. How is that fair? So you need to tap on those kind of heartstrings. And then for you guys you are not just the big fat cats, right? You're doing this also for all your employees, because if you can keep going, the company continues to run, everybody keeps their job. Otherwise, you go into bankruptcy, how many people are laid off? Again, so then that's a fact that's good for you. So the legal principles are to help these people. So these people must be the center. Then we use the principles to say, then that's how we interpret the law so that we can make it work.
Actually, right, small question, because this is regards to the reply. So on an instinctual level, it feels wrong that a court can grant a remedy in a foreign proceeding, but not in a domestic proceeding. Just your instinct that feels wrong somehow, right? Okay. Because I don't think any jurisdiction has just done that so far, because the limits of my current case law is 15 can grant remedy even if 11 doesn't specifically say can. But now we've encountered the problem where they specifically say cannot. So yeah, so then it's undecided now. So like the current angle is to mess with the true, like what Purdue Pharma actually stands for. Because the words of the judgment is just we bar non-consensual third-party releases, full stop. But then the current debate is what what that actually means. Because I think a lot of the US practitioners kind of cannot accept that this is the case.
Yeah.
So, as in like,
Well, see, right?
yeah, it's,
in terms of it.
yeah. So like
And all these articles, are there arguments you can borrow there to knock Purdue down?
the current one that we've picked, the current one we've picked is the one about purpose. Because it's like they submit that at least the various practitioners, the common consensus is they only were so harsh on this because the releases there were damn jialat, because it was for past future claims for everything including fraud and negligence. So then we submit that the true holding of Purdue Pharma is that this kind of releases would violate the purpose of Chapter 11.
I know, right? So that's actually really fine. I don't remember you saying that.
Because our current argument was that it is that the purposes of Chapter 11 is to regulate debtors and creditors, but Chapter 15 is committee.
Oh.
Or something like that. Because that's what another fella said. So now we're like,
They are, to me, they're complementary.
yeah, but like that has invited some trouble here.
Yeah.
So I assume now that it's more preferable to say the true holding of Purdue Pharma is they want to prevent evil. Here, no evil. Okay.
It's always be the good guy.
Okay.
Both sides are always
Okay.
depending on who's arguing.
Yeah. So like our current split on this issue was, are we respecting committee or are we not evil?
See, you do an 11 here, 11 there, 11 everywhere. Then 15 is just to recognize, right? So 15 is kind of based on 11. I mean, the principles are not different. I think cannot recognize something that's bad, you know? And if something is bad, then you cannot try even to knock it through.
Okay.
Yeah.
Okay, so it's like, oh, here our releases is just past contractual claims. So where is the evil? There's no evil. So we can recognize here.
Something like that.
Something like that. Okay.
Both sides need to use Purdue, one side to distinguish and one side to say it applies, but much more closely with the facts.
Okay.
Use the facts of Purdue compared with the facts here.
Okay.
Purdue is big enough for either side to try to extend.
Yeah.
I think that's why we put Purdue here. But for 15, the underlying issue is always public policy acceptance. Try to link something in Purdue, and then link it to the public policy here, and so therefore I would recognize it.
Okay. Because I think there's some resistance to guessing the true holding of Purdue Pharma, because if I recall correctly, the judges there, the majority judges specifically didn't want to comment on the public policy ramifications. Then some judges are like, oh, then let's not talk about it. But some judges are like, they just say one, like, of course they have public policy considerations. This is a mass tort claim and so of course you should discuss it. So there's a bit of a split on the feelings for this one. So I think the facts seem more interesting for.
I think you can't avoid talking about Purdue. You can't avoid dealing with it head on for both the cases.
Okay.
You must have you must be able to rationalize it in your own heads. Otherwise, I get the sense that you guys are scared about it. Like, I'm talking about this issue, I'm not sure where I should go, you know.
Oh, so just mooting wise, that feels weak,
Yeah.
Okay. Understand.
Judges like I ask a question or I make a point, say, I got this, I want to say this, I want to say that, you know, because this applies, this doesn't apply. Some kind of certainty to things, you know.
Okay.
But it's also good to recognize, like, look, it's not clear from here, but this is what I'm saying, and I'm saying this for these reasons.
Okay. Thank you.
I've got questions like this, you know.
Yeah, I think I've asked a lot of mine already.
I mean, we're all lawyers, we all have different ways of dealing with stuff. So I think these are just our suggestions. We have to decide how we want to use it.
Okay.
But your suggestions have been quite helpful. It's like, I think we sort of have the base, but I think we're still refining, thinking about framing. Yeah, it's not the framing that I think is still.
I suggest all of you are okay on the law, but the facts are where we need to get up on, and the portraying of why you guys ought to really include this is need more Yeah, my 1, 2, 3, you know.
Yeah.
Okay.
Okay. And then nothing else for us?
Who are
Okay.
the judges, do you know?
No, but I'm sure.
When is the next week?
Oh, okay, and who's on the other side?
We are going against City University of London.
Okay,
And we are going against an Indian team, but we don't really know the Indian team school.
They go hide the school email.
Yeah, they just put
You
that.
cannot see. Yeah.
so to say, even their own council can't put them on. How much they will go and hack things, you know? Which law firm?
I hope the outlines won't be confusing.
It's very confusing.
Sorry about that.
No, the facts are very confusing.
Oh, okay. Yeah, that's it. It's a very common trend we've been getting
It's
from all the
a
judges.
universal comment. Okay, but thanks for bearing with us for the time. Thank you for your time.
You.
Going to which, have you all accepted the training contract already? Going where? I just want to know.
Oh, yeah.
Oh, yeah, how come? Which year are you?
Year 3.
I haven't got,
Yeah, but
but yeah.
No, I mean the team that I wanted rejected.
Oh, I see.
Then my other options were not fantastic.
I see.
Yeah.
So where you're going?
Undecided for me.
You also have it.
Yeah. I just want to take another year to think about it.
Oh, okay, okay. I tell you what, all of you?
Am I going Davinder Singh?
Oh, okay. But they don't do in song at all.
I'm not sure though, but I think they are mostly on the commercial disputes.
Yeah, correct. Yeah.
Oh, they don't do
Not so.
it. Yeah, I think so.
Yeah. That's it? I'm not that.
I'm going Monkey.
Okay. Okay.
Yeah.
Okay.
South Sea.
No, CCD.
CD what?
Sweden.
Oh.
Sweden.
The two of you, if you want and you're not decided, come and do it in teams with us.
Okay. We'll take
Yeah.
note.
Yeah. Okay, give your names to her. We expect you to come.
Okay.
Not I mean you have internship coming up, right? Is it me?
Yeah, that's how I'm.
Have you applied already? Have you applied?
Not yet.
Yeah, clear by record.
Yeah, I think sometimes you can decide. And the best way is really to go and do internship. Yeah, do it about it lah. Then we learn something.
But I thought Drew cannot choose the team when you get the training contract.
Who told you that?
Your partners.
Indicate a preference.
You can indicate a preference.
Well, not guaranteed, right?
Yeah, but that's, I mean, we want to screw around people. I mean, we can't guarantee because we're coming so many years down the road. So we typically will not guarantee because that's not really how it works. But typically, if someone says, I would like to work for this person, we will try our best to accommodate one. It wouldn't make sense for us to not accommodate, right? But I think some people say, I want to know for sure I'm going to work for this person. Then sometimes we will say that we can't really tell you that much. Yeah, but everybody, it's all what you're doing now, persuading people. Persuading people means you always try to give them the lowest common denominator that you will accept, right? You don't have such a high threshold, Yeah. Yeah. So okay. We take it, that's an
Okay.
so she can tell you what the thoughts are like. I mean, look, if you're 3 years already, you should just do it because you don't have that much time.
Okay.
If you don't want to come, I don't want you to be kind of, induce which of contract. But if you would like to come, just let Chen know. So we'd love to have you in our team just to see. I mean, you guys do insolvency. We do that. I go to court. He goes to court. Actually, all of us go to court here also, but they also do the more consensual stuff.
So do you do the consensual stuff?
Me personally, not so much. I prefer to be arguing in court than to be across the table, negotiating a term. But we have guys who do that. Yeah. But we do a lot of the insolvency work, doing CROs, maybe some China insolvency. So I do a bit of the kind of across the table also in terms of the drafting. This is a China restructuring that we're doing. It's the first time that we're doing it out of Singapore, which is quite cool. Because China restructuring is whole new rules by themselves kind of restructuring. Yeah. So okay.
Yes.
I don't think so here now, right?
No, not for me.
Oh yeah, I did it under Merrill.
Oh, which is IT.
Yeah, it was like a while ago.
We can always come back.
So, no? Okay.
Hmm.
Well, you don't
Okay.
know what you're missing.
Okay.
Thank you.
Thank you.
That you don't